Enforcing Judgments in Malta, a legal and compliance update.
Good morning, everyone. So I have the pleasure of giving a short update on what's been happening with the thousands of player claims, mostly from Austria, that have come to Malta for enforcement against Maltese licensed operators. And with me today, I have two litigators, one from DLA Piper in Vienna, Nicole Daniel, who's triple qualified from Austria, England, and New York, and part of DLA's litigation and regulatory team, who advises clients on all things litigation and competition law. So Nicole and I will be going through what's been happening with player claims from Austria. And I also have the pleasure of having Albert Knigge. I'm sure I destroyed your surname, Albert, sorry. Albert is a partner at Hoothoff in the Netherlands, a member of the firm's Supreme Court litigation team, with a particular interest in class action litigation, mass claims, settlements, and follow-on civil litigation. So I'm in very good company today. As regards the Austrian player claims, so from the Maltese perspective, what we've seen is two landmark judgments delivered in February, where the Maltese First Hall of the Civil Court has refused to enforce two judgments from Austria on grounds of breach of Maltese public policy. So our arguments are that this is in line with EU law and Brussels recast, and therefore there are no arguments to be made on Article 56A of the Gaming Act, which was introduced in 2023 with Bill 55 being implemented. Most people still refer to Article 56A of the Gaming Act as Bill 55. The name has kind of stuck. So from our end in Malta, we've seen a slowdown of enforcement or attempts to enforce in view, presumably, of these judgments. But from our discussion, Nicole, I know that there have been developments in Austria as well, and I'd very much like you to share what's been happening in Austria.
Yes, so thank you for the kind introduction. In Austria, we've been creative. So for those who don't know the infamous Austrian player cases, we have a very strict licensing regime in Austria with just one online gambling license. So players can reclaim their losses when they played on any of the other websites, and they're doing that. So since enforcement is very difficult in Malta, plaintiff lawyers have become creative, and they turned to an instrument called Ordination, which is where the Supreme Court determines a locally competent domestic court. Here you have some statutory requirements, and one of them is that enforcement is impossible or unreasonably burdensome. So this is what has been happening, starting off with .com domains, now moving on to assets of operators in Maltese banks. It's very unusual because you would use this instrument historically for countries where there is no proper judicial system, certainly not in relation to EU member states.
So traditionally, this would be an action that's used with countries with, let's say, very weak judicial systems, right?
Yes.
But it's been successful in Austria so far?
Yes, because it's a unilateral procedure. So plaintiffs apply at the Supreme Court, and because it's unilateral, that inherently carries the risk that the Supreme Court only hears the arguments of the plaintiff and the supporting documents. And that's also a big critique that we have in legal circles, because as you can imagine, we took this up with quite, it's wondrous that you would do it in relation to an EU member state. So the online operators are not heard, they are not summoned, which is a massive issue. And the other thing is, you don't know what the practical implications will be, because I can't imagine Maltese institutions complying with garnishment orders from a district court in Austria.
Yes, sitting here as a Maltese litigator, I can't see Maltese banks complying either. But we still have to see what will actually happen, which makes me quite nervous. As you know, the European Commission has also recently given notice to Malta about infringement proceedings on Article 56A. The judgments that were delivered in February were not based on Article 56A, so the two matters are completely separate. So the judgments are based on Brussels recast arguments, public policy arguments, and they're being appealed now in October. We have the first sitting. But the infringement proceedings that the European Commission has initiated have to do with Article 56A, Bill 55 of the Gaming Act. I know you're familiar with the Advocate General's opinion. Do you have any comments to make on the Advocate General's opinion?
Yes, so we know that there are some managing director claims in Austria, and that mainly relates to online gambling operators who are not settling claims and who are not paying judgments. So to exert some pressure on them, they were sued together with their managing directors, claiming that managing directors are responsible for the offering of online gambling during the time frame where the plaintiffs gambled. And so questions were referred to the CGU, and essentially the Attorney General said that the alleged breach is a tort and that Austrian law is applicable because the place of damage is Austria. This is a very consumer-friendly view that we are seeing. He rejected the manifestly closer connection to Malta because the online gambling operators are situated in Malta, essentially saying that Austrian players are residing in Austria, they are playing in Austria, and the websites are targeted at Austrian claimants, or players, respectively, now claimants, most of them at least. So we'll see whether this is confirmed by the court, and in relation to the cases already pending in Austria, they were suspended because we are awaiting the decision of the CGU, and the claims are already based on tort. So as soon as the decision is handed down, and if it confirms what the Attorney General has said, then we probably have jurisdiction in Austria. We have Austrian law applicable, which does not automatically mean that managing directors are liable, because again, you have some statutory requirements for liability, which a very important culpability, and depending on the time frame when they played, the later the time frame is and the more Supreme Court judgments have been handed down saying that the offer is illegal, the higher the probability of culpability. And most important, the statute of limitation here is 3 years from knowledge or possible knowledge of the damage and the party responsible. So here we will see how the courts interpret it, whether in a consumer-friendly way or not.
A bit of a trick question for you, which we didn't discuss before the panel. But do you think anything is going to change in Austria once the monopolist license expires? Do you think there's going to be any changes in the law? It's set to expire in 2027,
yes,
right?
30 September 2027. Well, a tender for a new license should have started by now. It hasn't. They are, like the government is or the Ministry of Finance is currently working on the draft for the new Gambling Act. There's lots of gossip going around, but we still don't know whether there will be just one license again or more licenses, which we hope, because a better regulated market enhances player protection in general. So we will have to see. I think most importantly now for the industry will be what the CGU states in relation or held in relation to managing directors, because their liability, difficult for the operators if the managing directors start becoming liable, of course. And then we'll see. It really depends on what they will do with the amendment of the Gambling Act.
Okay. Albert, over the past 2 years since I've been neck deep in these cases, I keep being told, expect a wave of claims from the Netherlands. This hasn't happened here. We have not had this wave of claims from the Netherlands. Could you give us some insights as to what's happening in the Netherlands and why perhaps we haven't had this wave of claims?
I think in the Netherlands things are still developing. What we see currently, there has been a Court of Appeal ruling in 2016, Court of Appeal in Amsterdam, saying that the gaming transactions, transactions with online gaming business, they are not void, they are valid. So there's nothing wrong with these transactions. But after that, lower courts have chosen a different trend. So what we now see are multiple individual claims brought. Currently, there are dozens and dozens of those claims. There are approximately 20 judgments in lower courts, and I think 75 or 80% of them say that a transaction with an online gaming provider that has not been licensed in the Netherlands is void. So that's a new development that has been ongoing since the last 4 or 5 years. And at the same time, what we also see, as you know, our jurisdiction is a big hub for mass claims and class actions. What we also see are funders gearing up and preparing to bring mass claims on this basis. But that's still in a preparatory phase. Everything is now waiting, I think, because in one of these cases, before the district court in Amsterdam, the case has been referred to the Supreme Court in the Netherlands for a preliminary ruling on the question whether a transaction entered into with an online gaming provider that was not licensed in the Netherlands, whether that is void or not. And we've been submitting our opinion on that on behalf of the industry in that matter, explaining, providing all kind of reasons why the transaction is not void. Most of all because that would be against the free movement of services within the European Union, because an absolute ban that was enforced until 2021, because after 2021 it has been there. You can get licenses. Before that, you could never get a license. That was simply not possible because the law wasn't there yet. But the regulators always have channeled the activities and has developed a tolerating policy in which they encouraged gaming providers, online gaming providers that were licensed, for example, in Malta or in other jurisdictions and were regulated, they tolerated those activities.
So would the individual claims be suspended pending this referral? Is that why we've seen a slowdown and we've not been bombarded here?
Exactly. What we see now is because they are waiting for the preliminary ruling of the Supreme Court, that all the cases in the district courts are on hold. Meanwhile, we also see claim vehicles starting to prepare and they're using the GDPR to get transactional data for building their claims.
We see that here.
Yeah.
So we see that here as well, with requests for access to data in preparation for litigation. How is that being treated in the Netherlands?
Well, in principle, the rule is that the data should be provided, provided that it is asked in a legal way. And what we have seen some claim vehicles trying to do it on behalf of people, and that was rejected by the courts. But if it is asked on an individual basis with a proper mandate, the order is that it should be disclosed. I'm aware that in Germany, for example, if the intention is to get that data with the clear intention to bring a claim, there has been a ruling that is considered to be abuse of law, and on that basis it has been refused. We are arguing that also in cases, but we'll have to see how the courts will deal with that. So.
That could be an inspiration for us here to also change the law. We're running out of time, but I would like one final comment from each one of you on the topic. For where I'm sitting, I see things as very much in flux still. So it's been a long fight. We've been fighting in court for 2 years. The appeal here will be the final stage unless there's a retrial or some constitutional referral, which I highly doubt, apart from referrals to the CJEU. Where you're sitting in Austria and in the Netherlands, how do you see the landscape?
as for Austria, I think the next few months will be decisive, because then we will know what the new licensing regime will be in Austria, and also the decision of the CGU will be decisive in relation to managing directors, I have to say.
I agree.
Yeah, until the Supreme Court has given its preliminary ruling, I don't see big developments in our jurisdiction, and I'm expecting it in the Q1 or Q2 next year. So that will be a decisive moment, I think, how things will develop. And we have good hopes that it will be in favor of the industry. But, yeah.
Thank you very much.